this afternoon. So we're recording now. And thank you to Aoife and Colin for joining us this afternoon. I think I know many of you who are on the call, but for those of you who don't know me, I am a Leverhulme Early Career Fellow at Newcastle Law School. I do quite a bit of work around equality and anti-discrimination law from a feminist perspective. I'm interested in their impacts on women in particular. And I'm also the chair of Women's Platform since the beginning of this year in 2026. I know there are some people on the call who could say maybe a bit more about the history of Women's Platform than I could. I see Liz Law and Brona Hines on the call, but just to say that Women's Platform from the very beginning has really been about connecting women in Northern Ireland to international networks and making international human rights frameworks real for women in Northern Ireland, and making sure that women's voices in Northern Ireland are heard within those international networks. So we're very pleased to be able to bring people together this afternoon to talk about this judgment in Dillon, which is a really significant judgment that has implications for how this international treaty between the UK and the EU will work and will have impacts on women's lives here. So I won't keep you for very much longer, really. I'm going to hand over to Colin and then Aoife. I'll introduce you both now, I suppose. So Colin is Professor of Law and Democracy at Newcastle Law School. Who has very wide-ranging expertise, but has done a lot of work and has extensive expertise on Brexit and the broader UK constitutional order, but Brexit and its impact in Northern Ireland in particular. Aoife O'Donoghue is a Professor of Law at Queen's University Belfast. She has extensive experience also in researching on Brexit and Northern Ireland, has published academic publications, but also reports for the various commissions across the island in the UK. And her research interests focus on international law and constitutionalism, with a particular focus on law's impacts on women. So without further ado, I think I'll hand over to you, Colin, if that's okay.
Thanks so much, Ashton. I'm just going to share some slides. Please let me know if anyone can't see them. They're coming up now. And hopefully this will help to illustrate what I'm saying going through this session. Now, what I'm going to try to do is briefly introduce this judgment and why I think it's so problematic for rights protections under Windsor Framework Article 2. And then I'll hand over to Aoife, who will be going through in much more detail as to, well, if I'm doing the general picture of Dillon, what the implications are for a wide range of rights affecting women in NI. And so hopefully these two sessions will go together and we'll leave time for questions at the end. Forgive me if this is quite a rush, because there's an awful lot of material to get through in trying to explain these arrangements. And I suppose where we start is with the withdrawal agreement at the end of Brexit. And we all remember the endless debates about NI's law and how it was going to change after Brexit and what the special deal was for NI. But a lot of that debate related to goods and trade arrangements. There wasn't a lot of discussion about the special rights arrangements that were being put in place under the withdrawal agreement. Now, some would have you believe this is because they were not very important. It's really the opposite. They were so fundamental that the UK government couldn't very well claim that its Brexit was going to be 1998 agreement compatible without making special rights protections and equality protections a part of this deal, because EU law had underpinned rights protections from the moment that the 1998 agreement was signed. It was the main basis on which anti-discrimination measures operated within NI's law at the time of the 1998 agreement. And the right significance has only grown since into areas as far-reaching as immigration law and data protection law. EU law has continued to expand. And when we talk about rights in NI, what was being put under threat by Brexit were all of those commitments to rights that were bound up in NI being part of an EU member state. So the UK, very early on in the Brexit process, agreed what became Article 2 of the Windsor Framework. And the wording of this commitment hasn't changed since the earliest drafts of the agreement in 2018. So it wasn't constantly rehashed like the trade arrangements. And the reason for that is it was so fundamental. The degree to which rights and equality in NI depended in certain areas on EU law, and therefore the 1998 agreement's rights and equality commitments depended on EU law, was not arguable. And if the UK government wanted to claim Brexit was Good Friday Agreement compatible, it needed to make these commitments. But it's important from the outset to realize it made these commitments, but the wording of them is pretty complex. It takes some unpacking to understand what this couple of brief lines at the top of this slide mean. No diminution of rights, safeguards, or equality of opportunity, as is set out in the relevant chapter of the 1998 agreement, including with regard to protection of discrimination. Now, what that made for is two different types of obligation. There are protections against discrimination listed in Annex 1 of the Windsor Framework, and these weren't affected directly, or they weren't implicated directly in the Dillon judgment. So this is really important when it comes to women's rights in NI as a jurisdiction, because it covers the Equal Treatment Directive. So all of the protections that exist, not only for sex gender as a protected characteristic, but also for race and ethnicity, for disability, for a range of protected characteristics in areas like employment, access to goods and services, and even into areas like access to education. But there's also a wider obligation. Look at the wording that I have in bold in the top box. The no diminution commitment includes the Annex 1 directive, so it goes beyond them. There's a wider idea that other areas of EU law might touch on rights in Northern Ireland. Now, what that means is this part of the commitment, the wider non-diminution commitment, is at issue in the Dillon case. And what Article 2 effectively asks you to do is imagine NI was still part of an EU member state. And if it was still part of an EU member state, is there an issue of EU law affecting rights that is live in a case? And could the UK government or the Northern Ireland Assembly, in making laws, do the changes that they're seeking to make if NI was part of an EU state? So what you have to find to make this legal test work is some relevant EU law relating to rights, and we know that goes beyond the Annex 1 measures. That's clear on the wording of Article 2. And then you need to connect it to the wording of the 1998 agreement's rights, safeguards, and equality of opportunities chapter. Now, on the right of this screen, you'll see the first paragraph of that chapter, and it sets out a bullet point list of rights. Now, what I need you to see from the outset is that those rights are only examples. The parties affirm these rights in particular, but the parties are more broadly affirming their commitment to mutual respect, civil rights, and religious liberties of everyone in the community. The 1998 agreement is saying NI, after this date, after a history of discrimination and rights abuses is going to move forward on a different basis that embeds rights and equality protections as fundamental to the jurisdiction. And here are some examples of what that means. But it's not an exhaustive list. The parties affirm these rights in particular is the clear wording of the 1998 agreement. So if you can connect part of EU law to one of those rights commitments or to that general rights commitment in the RSEO chapter, that began to be your basis for saying Windsor Framework Article 2 was engaged. Now, the UK government tried to explain in general language what was meant by its commitment. It put out an explainer document in August of 2020, and it said, well, what do we mean by this non-diminution commitment? Well, we mean people are able to rely on it in domestic cases, and it goes beyond the Annex 1 directives. And you'll see in the box on the left, they said, here are some examples of the bits of EU law that we think it applies to. These include, but are not limited to, and then the UK government didn't at the time promise the moon on the stick. It gave 3 examples of directives, bits of EU law that it thought were engaged by this obligation. The Victims Directive, the Parental Leave Directive, and the Pregnant Workers Directive. Now, it kept going after that. There are repeated references to how the Victims Directive is part of the UK's obligation, but only insofar as it relates. The UK government started to say, trying to effectively limit it down to the aftermath of the Northern Ireland conflict. Now, in the Dillon case, what was at issue was the Legacy Act of 2023. And in particular, when the Windsor Framework and the Victims Directive are in play, one particular part of that very controversial piece of legislation. So there are lots of rights grounds to question the Legacy Act. For Windsor Framework Article 2, the particular thing was at issue was that the Victims Directive includes an explicit ability of someone who's been the victim of crime or their family members to challenge a refusal to prosecute. Now, that was part of the directive because EU law was trying to make sure that all of EU member states don't parcel off certain crimes and make them acceptable, put them on the statute books, but prosecutors never bother to prosecute and the police don't do anything about them. So there was a right to challenge a non-prosecution decision. And the Victims Directive applied because the Legacy Act, as it was enacted in 2020 by the Conservative government, included a general amnesty provision. So any crimes that were connected to the conflict were excluded from ordinary court processes, both in civil law and in criminal law. And because of that exclusion, victims said, if NI was still a member of, our rights under the Victims Directive. And so that was the basis of the Windsor Framework claim in the Dillon case. Now, there are lots of reasons to be concerned about the Dillon judgment. It leaves the law a lot less clear than the Northern Ireland Court of Appeal, who had previously decided the case, had set out the law relating to the non-diminution commitment. You can see here, I've flagged some paragraphs of the judgment. The Northern Ireland Court of Appeal relied on one test for making the non-diminution commitment work. The Secretary of State for Northern Ireland, Hilary Benn, suggested a totally different test in paragraph 128. And at the end of 128, the Supreme Court doesn't definitively say which of these tests works. So on very many levels, the first problem with this judgment is it's not doing the job that a higher level appellate court should be doing and setting out how do we rely on these rules. It muddies the water and it makes it very difficult to say what's the correct way for a claim to proceed on. More than that, it does recognize that the UK had committed to something when it committed to Article 2 of the Windsor Framework. But on one level, it very well couldn't not do. Parliament had brought in legislation linked to the withdrawal agreement, and that had amended the Northern Ireland Act 1998. And if you look at those sections, Section 78C and D of the Northern Ireland Act 1998, they spell out that the Human Rights Commission and the Equality Commission can bring cases and intervene in cases brought by others under Windsor Framework Article 2. So the Supreme Court had a problem. Parliament had said there is a clear legal set of obligations that are being brought into NI law by this measure, and they can be used by people in NI courts. It was very difficult for them to completely say that Article 2 had no legal worth, although the UK government tried to run that argument. But what the judgment does from that point onwards is try to be as restrictive as possible as to what that means in practice. Now, this is going to get quite technical and legal, but I'm going to try to cover it quickly. And what you need to see at this point is just the extent to which new hurdles are being added into the process. What they tried to claim, and it's in the last couple of sentences here in the paragraph that I'm displaying, is that when it comes to the rights provisions of the Belfast Agreement, the measures in question in the RSHO chapter have a high degree of generality and aren't drafted with the same specificity as other bits of the agreement. And they tried to use this to say, we don't think that very much of this can create legal obligations. Now, the problem is that I've showed you the wording of paragraph 1 of the Rights, Safeguards and Equality of Opportunities chapter. The issue isn't that these provisions are vague. The issue is that they're broad. And the NI courts up to this judgment had fitted a broad range of cases within them whenever an issue touched upon civil or religious liberties. Instead, the UK Supreme Court is doing this to say this is too unclear to provide a basis for direct effect, which is a technical EU law concept whereby EU law generates obligations within domestic legal orders. And it used that argument to say the Victims Directive, we can't see a way that it connects to a sufficiently clear part of the Rights, Safeguards and Equality of Opportunity chapter of the 1998 agreement to engage actionable rights in this case. That's paragraph 133 of the judgment, and that's the absolute core of the decision. But you only get to this core if you've seriously trimmed the relevant understanding of the 1998 agreement. And what they did in paragraph 118 is say, well, we can see bits of this that might have direct effect, but it's only where the specific bullet point list that I flagged earlier is at issue. Only then can measures be said to have direct effect. Now, that's a real problem because it's taking an EU law concept, direct effect, and it's applying it to a non-EU law treaty, the 1998 agreement, to make it more difficult to use that agreement. And then claimants would have to say there is also an actionable bit of EU law, like the Victims Directive in play. So it's almost double counting direct effect to make it much more difficult to bring claims and to shrink the ambit of the agreement. Now, more than that, in paragraph 119, it says paragraph 1 speaks to a high level of generality. Again, it doesn't want to recognize that these are broad rights connections. It says they're big claims of the civil and religious liberties going forward in NI after 1998. But what the court does is say everything in paragraph 1 relates to a recent history of communal conflict. All the rights listed in paragraph 1 were with regard to ending a sectarian conflict. So it's really saying you need to fit a claim within this narrow list of bullet point rights. And we think, because this is in the realm of obiter dicta, a legal term for sort of other things being said by the court, but really important in the context of a unanimous Supreme Court judgment, we think that you're only going to be able to mount a successful claim if it relates to the sectarian conflict. So the ambit of the 1998 agreement and the way that it creates rights is dramatically shrunk. Now, what about those promises? Because again, the claimants in the case had said the UK government has said the Victims Directive is covered by non-diminution. It covers that in the 2020 explainer. Well, the Supreme Court says we think that's just an example of subsequent state practice. So it's a statement that the UK government has made that doesn't have any binding effect on its international law commitments. It then cites a range of law that I just don't think is particularly relevant, because the key difference for Article 2 is it's a unilateral obligation that the UK took on itself, and it was making that statement in the explainer at the time that we were still in the Brexit implementation phase. The UK government was throwing out promises in, let's face it, what is a post-conflict society in NI? And it was asking people to trust those promises and say, these are the basis of your new legal rights. And the second someone tries to rely on those promises, it ran to the courts and tried to say they had no legal value. That's a really dangerous place for one of the guarantors of the 1998 agreement to be in. So these amounted to subsequent practice, and we don't think they can have any bearing, the court said, on our understanding of these measures. So in summary, where does that take us to? Well, imagine before the position of the NI courts was of a broad tapestry. All you had to do was fit your claim within some aspect of civil and religious rights, and then you had to show how EU law was supporting that to mount a Windsor Framework Article 2 case. Now, that's a broad tapestry, but it's not without limits. You could say, for example, environmental rights would be very challenging, even though there's lots of EU law that's relevant to that, to fit it within that tapestry. What the Supreme Court has done instead is say, we're going to reread the 1998 agreement and the rules around Article 2 so strictly that it becomes an almost half-court shot in basketball. You have to thread the needle with a claim through a series of hoops that we've put in place. And these hoops have become so questionable, especially in terms of reading the conflict into everything, that it's not that the game is just difficult, but the game is rigged against any claimant seeking to bring a case under these rules. Take a look at the UK government's other promises in the 2020 explainer. The Parental Leave Directive, the Pregnant Workers Directive, bits of EU law that directly protect the rights of women in NI. And cast your mind ahead a few years to a reform UK government that has threatened to tear up a lot of those rights protections and focus instead on affirming women's place in the home. Well, if those protections were taken away, could you use Windsor Framework Article 2 to secure those protections in NI? Well, again, you can show EU law that existed before Brexit. You could even, when it comes to the bullet point list, start to fit those within the bullet point that relates to equal opportunities in access to employment and the workplace. But the UK Supreme Court drew a very narrow line on what the Victims Directive meant, and they imposed this conflict connection. It said everything has to be read as addressing a sectarian conflict. And the more of these pieces to the jigsaw puzzle they add in, the more difficult it gets to make a claim. So to finish off, up to this point, the Northern Ireland Court of Appeal in Dillon had given a pretty conservative decision. It wasn't radical or activist. It was grounded in what the UK government had promised, had explicitly promised, that Article 2 meant. The UK Supreme Court's decision instead inserts loads of new hurdles. It's regressive. It keeps this framework of Article 2 in place, but it hollows it out. If you ever try to use it in practice, it has no substance to it, or radically less substance than it had before. This isn't the end of the story. There is still the issue of the Annex 1 directives. But if you apply the conflict connection requirement there, even they get much harder to use. Now, a judgment like this can still be a breach of the UK's commitments that can lead to more litigation in domestic courts and arbitration proceedings. But if it's not confronted by further litigation and arbitration, NI law will be left with a really hollow version of Article 2 that does very little to protect rights in practice. Thank you.
Thanks, Colin. Sorry, I think we'll hand over to Aoife if you do you want to share your screen?
Yeah, thanks. Thanks, Aisling. Just as I'm getting this up, it's important to say actually this is actually work that I'm doing with Aisling. Just to acknowledge that Aisling is represented somewhat in the slides, and her work is there too. So it would be very unfeminist of me to not acknowledge Aisling's work, and then we're going to be continue working at that. So I'm going to kind of carry on from Colin there and kind of talk more specifically about the impact for women that I foresee for this judgment. But before I do that, sort of using techniques of what's called feminist judgments, where judgments have to follow all the rules and procedures and laws that exist, but are rewritten from a feminist perspective. I'm going to sort of use some of those tools to kind of point out the harms I think that are produced. And one of the first ways it does that is actually the opening paragraph. Now, I think this first paragraph was quite shocking when I read it. And it's quite shocking in a number of different ways. First, because it carries on a very long tradition, going back to sort of Gerard of Wales in the Norman period, of describing violence on this whole island as entirely based on the people from the island, that the relationship with violence is nothing to do with Britain or our neighbours, that there isn't a sort of interaction going on. And this, in the way this paragraph presents it, not only as the Irish always fighting amongst ourselves and between ourselves, but that the UK government is some kind of sort of neutral arbiter in all of this, which is quite stunning in a case about legacy, including the UK government's own legacy in the Troubles. So it is quite, I think it was very clear from that very opening paragraph and the stark way that it was presented the way the judgment was going to go. It was always going to be presented about a judgment about violence and conflict that is only related to people doing it on the island, and specifically in Northern Ireland, and that the UK government was somehow neutral in all the ways that it sort of interacted with that violence. But I do think it is important that that paragraph is in some ways sets the tone that Colin has outlined in the way that everything that follows. There's also some other elements that I think it's important to highlight. The families aren't actually mentioned until paragraph 14. And I think that's significant as well, right? Because again, it's about legacy. And it was about the families who were taking these cases and were unhappy with the way that legacy was being dealt with in Northern Ireland. But they aren't the target of this judgment. They aren't mentioned till paragraph 14, and their concerns are not considered or discussed at all. There is no consideration of the impact of the decision on women, on LGBTQ plus people, on immigrants and others who have been relying on Article 2 to prevent their rights being taken away. They're not present, they're not mentioned. I mean, they talk about the earlier decisions that have been made, say like the Spock decision, which does relate to women's bodies, for instance, but they don't talk about the substance of those decisions or what they were about, or the impact of their, as Colin has outlined, 3 different potential tests that we could use to figure it out. They also talk about as Colin has outlined, about the rights not being detailed enough. Now, specifically in the context of the UK Constitution, that is actually quite extraordinary, because in many ways, the Northern Ireland Act 1998 and the agreement in 1998 are one of the most detailed parts of the entire UK Constitution, which is famously undocumented and relies on conventions and what's sometimes called good chaps constitutionalism as a way to rely on sort of like a cricket idea of we'll all behave properly, so we don't need to write anything down in detail. So the idea that they are displacing all these rights and equalities by saying, oh, and I think this goes back to the first paragraph, things have to be detailed, but for the rest of us, we can rely on this sort of good chaps vague. And I think it's particularly a problem because the 1998 agreement and the vote was an act of internal self-determination. It was people in Northern Ireland, and similarly you could say for Scotland and Wales in their devolution referendum. It was an act of deciding how the constitution here in Northern Ireland would operate. So there are just some general thoughts that sort of on the contents. Now the RSEO chapter, that part 1 that Colin was talking about, there's 3 elements of it that are important to women, because Article 2 itself of the Windsor Framework does not address women's rights and equalities, and nor does Dillon. Okay, so you could sort of, if you're being cynical, you could say, well, what are we even talking about women for? But the SEO chapter does talk about the importance of the advancement of women in public life, and to me that's quite a clear commitment. That's not vague. Includes women as members of the community, so it doesn't say women, and this is important, but women naturally are members of the community. It would be strange if we interpret the 1998 agreement to only mean the men of both communities, and only those 2 communities, and the right of women to full and equal political participation is also central. So women are active public citizens, or should be. Obviously, we have a long way to go, but women should be under the 1998 agreement. And of course, as Colin's outlined, those EU directives, 4 and you could say 5 out of the 6 directives, directly address women's rights and equalities. They're very present. They are the ones specifically listed as the rights that must be kept pace with. Now, it is important to state that that section was not before the court, so we don't actually know what they're saying about that. But it is very important. Women were actively present and listed as the types of equalities that needed to be protected, which of course is particularly important in Northern Ireland because there is no one Equality Act as there is in Britain, which covers equalities. The law, and this very much goes back to Aisling's work, the law is scattered all over the place when it comes to equality, including in these EU directives. Non-diminution. Okay, this is really important, I think, as well, in the way that this is interpreted. So the Dillon court in the Supreme Court, they kept talking about 1998. And we need to look at the rights in 1998 and what people meant in 1998. But non-diminution counts from Brexit Day. It's what were the rights on that day. That is the point we must look at. And of course, there's plenty to critique, and I'm sure everyone in the room is more than aware of all the things that still need to be done on women's rights and equalities. But they have advanced significantly since 1998. So the sort of idea that we must hark back, we must jump back in time, that clearly was not the intention of Article 2 in the Windsor Framework, or for the entire actual Brexit settlement. It is this date is the significant date. It is what the rights were on that date, not what the rights were coming out of the Troubles. And I think that's really important from the way that the judgments, the way that women are kind of removed silently through the judgment. So women who, trying to rely on Article 2 of the Windsor Framework, and as Colin said, it is, even before this judgment, it is kind of a complicated law. I mean, and it is spent a lot of time since trying to figure out how exactly it works and functions. But there is a minimum bar set there, right? So it's under the RSEO chapter, and that these must also, that the 6 directives must keep pace. And that actually goes back to the 1998 agreement as well, and the idea of equivalence on the island. Now, the UK government said that is actually only an obligation on Dublin. But if it wasn't, that equivalence is there, and the idea to keep pace was put into Article 2 to ensure that women's equalities were not going backward in Northern Ireland when in the rest of Europe they were progressing. And that is the intention of that. It is to ensure that across the island, women had the same equalities. Another part of it, I think, and Colin's touched on this, is the idea of everyone in the community. Now, this, I think, is a problem that not only the Dillon judgment, and I'm sure all of you are extremely aware of this as well, that women are often written out of the negotiations. They're written out of the very quiet piecework that they were doing that wasn't loud and showy and doesn't get things named after them and doesn't end up being headlining the very many anniversary celebrations that happen. But women's organisations were, of course, and many of you were, critical to the peace process, doing the quiet business on the ground. They were instrumental in ways that, and the women, the 1980 agreement, even if you look at like Peter Mandelson, the way that 1998 and negotiations were used, even though he came in quite late in that, to kind of clean up his reputation in some ways. Yeah, he did all these things, but 1998, none of that is accessible to women. And women were centre of the harms, but they were also centre to trying to undo those harms. And this becomes important when we talk about everyone in the community. So when the UK's Supreme Court's characterisation of the bullet points in the RSEO chapter is only relating to the sectarian conflict, and therefore only relating to nationalist and unionist communities. Now, very recently, in 2024, Humphreys J had said that everyone, and this was regard to an immigration case, that everyone meant all of those in Northern Ireland. And that was really important because we have a previous case, the Evelyn White case, which was about Evelyn White had tried to join the Parades Commission. For those of you unaware of the case, she tried to join the Parades Commission, and she took a case because it was all men, and she said, well, women need to be represented because women in public life, etc. And actually the court said no, that representation, everyone in the community, that actually only meant the nationalist and unionist communities. So the fact that there were no women present at all on the Parades Commission was entirely fine. Now, that was a terrible judgment. But it has been since overruled in 2004 by Humphreys J. But what the Supreme Court does, and it doesn't refer to the White case or anything like, because women aren't present in the judgment, but by going back to that understanding of everyone in the community as related to the sectarian conflict, I think opens the door to going back to that Evelyn White decision, to going back to say it doesn't matter if women are not present. It doesn't matter that women aren't represented. It doesn't matter, even that very minimum, right? Just being in the room. And that is the bare minimum. that doesn't matter and that's not covered. So I think that is a really important, that relationship that the Supreme Court, if subsequent courts follow that and follow the idea of the sectarian conflict and putting everything back to 1998 as opposed to Brexit Day, this is the kind of scenario we could end up back in. And I think that going back to the idea of Brexit Day, it's important, right? Because Article 2 was not drafted. There was no, as Colin said, it was very early settled actually. It was very early on. It was not drafted with the idea that it was going to exclude women, or else they wouldn't have had those directives. It wasn't drafted with the idea that they were going to exclude 20% of the population, particularly because it's EU, that they were thinking of EU citizens who would remain in Northern Ireland afterwards. So who wouldn't necessarily identify as, you know, over 20% of the population don't necessarily identify with those communities. There is no way to read the drafting of the negotiation or the interpretation by the governments or by the European Union that is how Article 2 was supposed to be. And it is important, as I said, that like the UK Supreme Court was not considering those 6 equality directives. There was a lot of talk immediately after Dillon about trans rights, and it does not impact on trans rights. It is not that they didn't discuss it, it didn't come up. Those Annex 1 directives where they were mentioned were, as Colin used earlier, the idea of obiter dicta, so just general statements that were made by the Supreme Court and therefore not binding. But that does not necessarily mean, of course, that it's not used to suggest that we should be interpreting all UK Supreme Court decisions to the exclusion of that everyone in the community, when this was being negotiated, did in fact mean everybody. That is how Article 2 was drafted. So just on kind of the future, and then we'll, you know, a bit of time for questions. I think my biggest concern is that, as Colin outlined, the case in Dillon is about legacy, and it was about the Legacy Act, and that didn't succeed. And so something about the sectarian conflict, if we want to put it in the words of the UK Supreme Court, about that directly, where victims are mentioned, you know, in the RSEO chapter, and that did not succeed. Something that falls squarely within the Troubles, within that first paragraph, and yet it did not succeed. And I think that suggests that it's going to be next to, I don't want to say impossible, but it's going to be extremely difficult for a woman or from anyone in Northern Ireland who's not directly connected, you know, to the sort of, you know, you can't make a claim to be in either of those communities, to take a case under that first section of Article 2 and succeed. I think that's particularly stark because the actual case itself is in fact about the legacy of the Troubles. Now, having said that quite negatively, and nobody is yet, I've yet to see anybody present an example of a case that would definitely win. And so, you know, there's various different discussion points coming out, but no one's presented me with an example of a case that would win. Absolutely. There are bits of the 1998 agreement that are still open to being done. There could be a Bill of Rights, which could ameliorate this. There's the idea of the Charter of Rights of the Island that most people now just forget was ever a proposal. Those things are politically difficult, of course. But also, I would generally be the type of lawyer who says you shouldn't rely on the judges for your rights anyway. And therefore, you know, I think it's important that we should, and that's not to say judges are bad, it's just, you know, courts change. You shouldn't rely on them as the only way. We could also, and this is very much Ashling's work, you know, look towards having a substantive piece of equality law in Northern Ireland. You know, it's scattered all over. It would be a way to lock those in, to lock in the legislative intent. A subsequent court could walk this back. It's a very badly written judgment. And when something is like it's just badly written because it's like written by committee, so it contradicts itself and it's just bad judgment writing. A subsequent court could walk that back, could walk it back, and you know. So while I say it's hard to imagine someone winning a case, I don't think that doesn't mean that taking cases is pointless, because a different judicial makeup, a different group of judges might come to a different decision, or they might interpret their way through and around it, which they do, because the idea that there's some courts are really neutral and some of them are really activist is like They're all activist. It's just some of them are quieter about it than others. And there's also the possibility of the specialised committee in arbitration. So there is, through the Windsor framework, a way for the dedicated mechanisms of the Northern Ireland Human Rights Commission or the Equality Commission to bring this up as a problem to the specialised committee, which then does a whole process. But it can go to an arbitration panel, which are full of very highly qualified lawyers and specialists who also may actually say, well, what does this actually mean to go to the Court of Justice of the European Union? So there are multiple different avenues that can be taken, that there can, I suppose this fight isn't over. But this certainly, there is, as Colin has outlined, real reasons to be concerned. I will stop there.